And I'll be talking about strict liability. And strict liability can be very difficult, but at the same time, after I finish explaining each and every element of what strict liability can look like, you may have a better foundational understanding of what it means and how to attack it when you happen to perform on an exam or when you're doing your MBEs. So let's hop into it. Let's get into exactly what strict liability means, the rule statement, I mean. So strict liability means that the defendant is liable, irrespective of whether anyone was at fault. So in strict liability, it doesn't really matter how careful the defendant was, as long as someone was hurt in strict liability in that situation, the defendant will be strictly liable for what has happened. Just like in negligence, for example, the defendant is liable for negligence because the defendant was not careful enough. The defendant was not reasonably careful. But in strict liability, it doesn't really matter how reasonably careful the defendant was. As long as someone was hurt by the defendant's activity, whatever the defendant may be doing, the defendant will be strictly liable for what has happened. So let's get into examples of really strict things that can happen within this tort. We have ultra-hazardous, abnormally dangerous activities. And also we have wild animals and domestic animals. So let's talk about ultra-hazardous, abnormally dangerous activities first, because it has 6 characteristics that I wrote over here in black. So we can understand exactly what it actually means, what actually constitutes an ultra-hazardous, abnormally dangerous activity. So we'll start with number 1. Number 1 is whether the activity has a high degree of harm. So number 1, we're basically examining on whether the activity that the defendant is doing is going to cause a high degree of harm to the plaintiff or anyone else around in that specific area or whatever situation that may be happening within the fact pattern. Number 2, the gravity of that risk. So will the defendant be likely to cause that harm by doing this activity, or is it better off to not perform the activity at all? That is what's critical for number 2. So number 3 is whether this activity can be eliminated by reasonable care. Again, in strict liability, it doesn't really matter how careful the defendant was. As long as someone gets hurt by the ultra-hazardous, abnormally dangerous activity, the defendant will be liable for what has happened. However, if the defendant could have stopped the activity in the first place, the activity would not have led to the plaintiff's injury. That's what number 3 is trying to tell us. And number 4, whether the activity is of common usage. So if the activity that the defendant happened to be doing is very arbitrary and is not common in our society, that very well could constitute an ultra-hazardous, abnormally dangerous activity. Okay? What's very common is construction work. That's very common. However, people could probably get hurt by construction work if not worn properly, if not, let's say the defendant wants to use his construction company to break down a building to build a new one, and the defendant doesn't actually take that reasonable care or determine within his or her mind the gravity of that risk, that it might hurt someone within that process. I guess that's an example of activity that's common usage, but something that is not really that common is maybe the defendant dealing with explosives. That's an example of an activity not being that common. Therefore, looking at the 4th characteristic of this issue is very important for the 4th mini element for ultra-hazardous dangerous activities. So number 5 is whether the activity that the defendant was doing was appropriate on the specific spot that it was carried on. This is how I said before with the construction work. It's proper to do construction work in a certain place. Let's say in a desolate place, not that far away from the public, that can probably constitute an appropriate place that could more than likely lead the defendant to not be liable for strict liability, because that'll be away from people and it won't cause that much injury to everyone around that area. However, an explosive close by a populated area, let's say Santa Ana or Los Angeles, very well could have a high degree of risk of harm, and it would not be appropriate because of the fact that it is more likely that someone could get hurt in a highly populated place when the defendant wants to perform an explosive. That's an example, number 5. So we get to number 6 is basically the value of that activity to the community. Example, like I just said, is construction work, someone trying to fix the road, things like that on the highway or even sidewalks. That is a very appropriate place and a very valuable thing that the community wants to happen because that will advance the common good. However, something silly like polluting rivers or local lakes or even the ocean could be something that is not valuable to the community. And that could be something that would not satisfy the 6th characteristic, and the defendant very well could be liable because the plaintiff could raise that it was not valuable to the community. Therefore, it's possible that the defendant could be strictly liable, assuming that that pollution causes harm to the plaintiff. So let's get into wild animals and domestic animals. I'm going to erase everything up here. So let's focus on the type of injury that could occur when the defendant has a wild animal or a domestic animal. There are 2 different situations. So with wild animals, what's important about that is basically the dangerous characteristics of that animal. So I'm going to write that down. So what's important about wild animals, and what's important about strict liability in order for the defendant to be liable for that tort, is that the ultrahazard or dangerous activity or the wild animal or domestic animal must have caused it. So causation must be there. The actual cause and the legal cause must be satisfied in order for the defendant to be liable for strict liability. So, as I was talking about, with the dangerous characteristics, the dangerous propensities of that animal must have caused the plaintiff injury. So we think about wild animals, the basics: a tiger, a lion, an elephant, a gorilla, a monkey. If the defendant owns an animal like that, it does not really matter how careful the defendant was, as long as the defendant's animal, the tiger, lion, etc., ends up escaping his or her lawn, or whatever the case. If that animal causes another person injury, the defendant will be strictly liable. However, it must be according to the dangerous propensities of what the animal is. If someone is scared of the animal and ends up running from the defendant's property into traffic and runs over by a car and gets run over by a car, the defendant could be liable for that because that is a propensity of the animal. That would reasonably scare anyone. If the tiger ends up trying to attack someone, that person runs away and gets hit by a car. That is an example of a dangerous propensity by the wild animal owned by the defendant, and the defendant being liable for strict liability. And another critical example could be that, let's say, the gorilla ends up scratching or biting the plaintiff because the defendant could not keep the animal under control. That is an example of one of its dangerous propensities, and the defendant being strictly liable for what the animal did because the defendant is technically the owner of that animal. Another example of someone being liable for wild animals and according to his dangerous propensities is, let's say that my brother wants to take care of my gorilla. He babysits it, let's say. Gorilla sits. And that gorilla, under his custody, hurts someone. My brother could be liable, strictly liable, because of the fact that he actually decided to take care of my animal and one of his dangerous propensities caused someone harm, caused the plaintiff injury. Therefore, he could be liable for strict liability. So let's get into domestic animals. Domestic animals is pretty much the same situation, but slightly different. Domestic animals has more of a simple, per se, rule statement. We're going to put DA for domestic animals. So when domestic animals, the defendant is usually not liable unless the defendant had knowledge. The defendant knew of the animal's dangerous propensities. So let's say the defendant owned a pit bull, and that pit bull ends up biting someone, and the defendant knew, the defendant had the mens rea per se, that that animal could be dangerous. That is an example of the defendant being liable under strict liability because he had a domestic animal that he knew was dangerous because of the propensities that it has, and the animal caused another injury. However, a small way to get out of a situation like this is if the plaintiff ends up provoking the animal. So let's say that the defendant has the animal and the plaintiff ends up pulling on the dog's ears, and the dog suddenly reacts and bites the plaintiff's hand. The defendant can raise the defense of assumption of the risk because the plaintiff assumed the risk by provoking the animal, thereby allowing the animal to bite the plaintiff's hand. That is an example of a defense that the defendant can raise in order to get out of a strict liability claim that the plaintiff will bring upon him. Moreover, we have a modern law and a common law split. So with common law, we have the one free bite rule. So basically, under the common law back in the day, dogs have one free bite. And after that, the defendant will be on notice of the animal having a dangerous propensity. And if the defendant's dog ends up biting someone again for a second time, the defendant will be strictly liable for what the dog has done to someone else. However, under the modern law, you'll be strictly liable, period. There are no free bites under the modern law. The common law was a little more lenient under domestic animals. However, modern law is a lot more strict now, and if your dog is biting someone, the defendant could be liable for that injury. So, to wrap up this video, I want to go over exactly what we just did. So like I said, in strict liability, the defendant is liable, irrespective of whether anyone was at fault. So in strict liability, it doesn't really matter how careful the defendant was. As long as the activity or the animal, domestic or wild, ends up causing the plaintiff some type of injury, the defendant could be liable for that act. And causation is really important too, because we have to have actual cause and proximate cause in order for the defendant to be truly liable. And also, the only defense that can really be used under strict liability is the assumption of the risk. That's why I love the example that I just used about the plaintiff provoking the animal and assuming the risk of getting bitten by that animal, because the defendant can use the assumption of the risk in order to get out of the claim that's filed against him for strict liability. So I hope this video helped you understand what strict liability means and what ultra-hazardous activities can be, and also what wild animals and domestic animals can do in relation to this tort. Thank you.